International Covenant on Civil and Political Rights, General Comment No. 21, Article 10, Humane Treatment of Persons Deprived of Their Liberty. 1. This General Comment replaces General Comment No. 9, the 16th session, 1982, reflecting and further developing it. 2. Article 10, Paragraph 1 of the International Covenant on Civil and Political Rights applies to anyone deprived of liberty under the laws and authority of the state who is held in prisons, hospitals, particularly psychiatric hospitals, detention camps or correctional institutions or elsewhere. States parties should ensure that the principle stipulated therein is observed in all institutions and establishments within their jurisdiction where persons are being held. 3. Article 10, Paragraph 1 imposes on states parties a positive obligation towards persons who are particularly vulnerable because of their status as persons deprived of liberty, and complements for them the ban on torture or other cruel, inhuman or degrading treatment or punishment contained in Article 7 of the Covenant. Thus, not only may persons deprived of their liberty not be subjected to treatment that is contrary to Article 7, including medical or scientific experimentation, but neither may they be subjected to any hardship or constraint other than that resulting from the deprivation of liberty. Respect for the dignity of such persons must be guaranteed under the same conditions as for that of free persons. Persons deprived of their liberty enjoy all the rights set forth in the Covenant, subject to the restrictions that are unavoidable in a closed environment. 4. Treating all persons deprived of their liberty with humanity and with respect for their dignity is a fundamental and universally applicable rule. Consequently, the application of this rule, as a minimum, cannot be dependent on the material resources available in the state party. This rule must be applied without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. 5. States parties are invited to indicate in their reports to what extent they are applying the relevant United Nations standards applicable to the treatment of prisoners, the Standard Minimum Rules for the Treatment of Prisoners, 1957. The Body of Principles for the Protection of All Persons Under Any Form of Detention or Imprisonment, 1988, the Code of Conduct for Law Enforcement Officials, 1978, and the Principles of Medical Ethics relevant to the role of health personnel, particularly physicians, in the protection of prisoners and detainees against torture and other cruel, inhuman or degrading treatment or punishment, 1982. 6. The committee recalls that reports should provide detailed information on national legislative and administrative provisions that have a bearing on the right provided for in Article 10, Paragraph 1. The committee also considers that it is necessary for reports to specify what concrete measures have been taken by the competent authorities to monitor the effective application of the rules regarding the treatment of persons deprived of their liberty. States parties should include in their reports information concerning the system for supervising penitentiary establishments, the specific measures to prevent torture and cruel, inhuman or degrading treatment, and how impartial supervision is ensured. 7. Furthermore, the committee recalls that reports should indicate whether the various applicable provisions form an integral part of the instruction and training of the personnel who have authority over persons deprived of their liberty, and whether they are strictly adhered to by such personnel in the discharge of their duties. It would also be appropriate to specify whether arrested or detained persons have access to such information and have effective legal means enabling them to ensure that those rules are respected, to complain if the rules are ignored, and to obtain adequate compensation in the event of a violation. 8. The committee recalls that the principle set forth in Article 10, Paragraph 1, constitutes the basis for the more specific obligations of states parties in respect of criminal justice, which are set forth in Article 10, paragraphs 2 and 3. 9. Article 10, paragraph 2a. Provides for the segregation, save in exceptional circumstances, of accused persons from convicted ones. Such segregation is required in order to emphasize their status as unconvicted persons who at the same time enjoy the right to be presumed innocent as stated in Article 14, paragraph 2. The reports of states parties should indicate how the separation of accused persons from convicted persons is effected and explain how the treatment of accused persons differs from that of convicted persons. 10. As to Article 10, paragraph 3, which concerns convicted persons. The committee wishes to have detailed information on the operation of the penitentiary system of the state party. No penitentiary system should be only retributory, it should essentially seek the reformation and social rehabilitation of the prisoner. States parties are invited to specify whether they have a system to provide assistance after release and to give information as to its success. 11. In a number of cases, the information furnished by the state party contains no specific reference either to legislative or administrative provisions or to practical measures to ensure the re-education of convicted persons. The committee requests specific information concerning the measures taken to provide teaching, education and re-education, vocational guidance and training, and also concerning work programs for prisoners inside the penitentiary establishment as well as outside. 12. In order to determine whether the principle set forth in Article 10, paragraph 3, is being fully respected, the committee also requests information on the specific measures applied during detention, example, how convicted persons are dealt with individually and how they are categorized. The disciplinary system, solitary confinement and high-security detention, and the conditions under which contacts are ensured with the outside world, family, lawyer, social and medical services, non-governmental organizations. 13. Moreover, the committee notes that in the reports of some states parties no information has been provided concerning the treatment accorded to accused juvenile persons and juvenile offenders. Article 10, paragraph 2b. Provides that accused juvenile persons shall be separated from adults. The information given in reports shows that some states parties are not paying the necessary attention to the fact that this is a mandatory provision of the covenant. The text also provides that cases involving juveniles must be considered as speedily as possible. Reports should specify the measures taken by states parties to give effect to that provision. Lastly, under Article 10, paragraph 3, juvenile offenders shall be segregated from adults and be accorded treatment appropriate to their age and legal status insofar as conditions of detention are concerned, such as shorter working hours and contact with relatives, with the aim of furthering their reformation and rehabilitation. Article 10 does not indicate any limits of juvenile age. While this is to be determined by each state party in the light of relevant social, cultural and other conditions, the committee is of the opinion that Article 6, paragraph 5, suggests that all persons under the age of 18 should be treated as juveniles, at least in matters relating to criminal justice. States should give relevant information about the age groups of persons treated as juveniles. In that regard, states parties are invited to indicate whether they are applying the United Nations Standard Minimum Rules for the Administration of Juvenile Justice, known as the Beijing Rules, 1987.